Interrogatories. Hi, I'm Doug Landau. I'm an injury and workers' compensation lawyer in Herndon, Virginia. Our buildings are located minutes from Washington Dulles International Airport and 20 miles west of the White House in Washington, D.C., here in Northern Virginia. We travel up and down the East Coast to represent our clients and devote an enormous amount of our time, effort, and resources towards helping people with their workplace accidents, car crashes, airport and airline injury cases, and even athletes who have been harmed by the unsafe decisions of other folks. We're going to talk about interrogatories. Interrogatories is the fancy lawyer's word for written questions that you answer under oath that can then be used at trial if you change your story. They're important. I've heard many times how a client injured in a crash or some other event goes to their deposition, and when asked about answers that they wrote supposedly under oath in response to interrogatory questions, says, "I never saw them before, my lawyer wrote that," or "the law firm must have made that up." It's important to work on your own interrogatory questions, talk about it with your experienced legal team, and then make sure you know what the final version looks like, because you will be asked about it, perhaps at your deposition and or trial. Again, interrogatories are questions from one lawyer to another party, usually the injured victim, asking questions about how the crash or injury producing event occurred, what injuries they claim to have sustained, questions about prior medical history, questions about work and wage loss, questions about other losses and harms, questions about things even as seemingly remote as prior criminal record, court and litigation history, and other things that are allowed into pretrial discovery. Pretrial discovery is the process whereby one side of a lawsuit learns as much as they can about the other side's story and claim, and they're allowed to ask a lot of questions and cast a much wider lasso than they can at trial. At trial, evidence is limited to that which is relevant to the issues, relevant to the questions that the court and the jury need to know. In discovery, they can ask questions in interrogatories that are not only designed to yield relevant evidence, but also things that may lead to relevant evidence. So it's a much wider swath. Things that they ask in interrogatories, in pretrial discovery, may not come in at trial, but they're still necessary for the process of pretrial discovery and the resolution of your personal injury lawsuit or your workers' compensation claim. So the main takeaways are: make sure you actually answer the interrogatories, you see the final version, you work with your legal team, and you are comfortable with the truthfulness and completeness of your answers. Again, I'm Doug Landau with Abrams Landau Limited. We are an injury and workers' compensation law firm located in Herndon, Virginia, right in the middle of the East Coast, in the Mid-Atlantic section, 20 miles west of the White House, and minutes from Washington Dulles International Airport.